My Lord, in terms of the documents that we were requested, a number of these, I understand, have already been sent to the registry. Those include the relevant sections of the Enterprise Act, the old CAT rules, and Lord Justice Mummery's report into the CAT rules. But we are still collating some of the additional documents, and we will aim to try to circulate those overnight.
Thank you.
My Lord, before we left, I was on the CAT judgment, and I just wanted to make one further observation about it, and that is just how rigorously the CAT approached the quantum of costs that were claimed by the appellants. The CMA, in its statement of case, draws attention to the fact, I think in support of its contention that there's an inherent chilling effect, or possibility of a chilling effect, that the amount that the appellants claimed in this case in costs came to some 7.7 million. And that is correct. They also sought interim payments on account of costs totaling 2.8 million between them. But if you read the CAT judgment carefully, it's instructive to see what actually happened to those costs that were claimed, because they were truly sliced and diced. And if I may just give you the references, but first of all, at paragraphs 58 to 63, the CAT disallowed various items of costs, which brought them down by well over 1 million. It then, as you've seen already, made the issue-based costs order. That brought them down collectively to 3.7 million, so less than half of what was claimed. And then at paragraph 68 to 70 of its judgment, the CAT went out of its way to state that even those costs were still subject to a detailed assessment, and that it considered them to be disproportionately high and expected further substantial discounts. And in Pfizer's case, it also expressed concern about the transparency of the costs claimed. And in relation to the interim payments, one sees in paragraphs 77 to 79 that they came down to a relatively modest £200,000 and £250,000 respectively, so £450,000 in total. So less than a fifth of what was claimed. So not only was this an issue-based costs award, but it was also an award that cut back very substantially the costs claimed so as to keep them within proportionate bounds. And in doing that, it faithfully and rigorously followed the approach laid down in the earlier case law, such as the JISC case that Mr. Briley took you to briefly, which stipulates that that is a method, an acceptable method by which any chilling effect can be mitigated. So those were not just empty words. They are an approach that is very much alive and kicking. And we say that if you look at what the CMA did in the round, it's extremely difficult indeed to see how this can be characterized as anything other than an entirely reasonable and balanced approach that is well within the CAT's discretion. My Lord, my Lady, if I may come next to the third part of my submissions, where I wish to go back to some of the case law. We've obviously attempted a fairly full account in our written case, and given the time constraints, I will just have a chance to, I think, dip into the cases and make a few additional points. The CMA, in its statement of case, paragraph 21, suggests that the common law principle with a capital P that it persuaded the Court of Appeal to adopt is one that is long-standing. And it goes as far as to suggest that it rests on a clear and consistent line of authority decided over 4 decades. Now, even the Court of Appeal did not put it that high. You see, for example, in the judgment of Lord Justice Arnold at paragraph 110, that he considered it a principle that had emerged in more recent years and was indeed not even complete at the time of the Perrin-Panathan case in 2013. But the notion that the principle, as now formulated, has existed for 4 decades is, in our submission, plainly incorrect. And one can see that if one goes back to the seminal case of Booth. And if I could invite you once again to take that up. It's in the authorities bundle, tab 18, so it's page 1181 of the bundle. And of course, Mr. Brearley has already taken you to this, and I just wish to show you some additional parts of it. We could go to page 1184 and to paragraph 8. And what one sees there are the submissions made on behalf of the local authority. And you'll see it said there, Mr. Booth, those submissions made on behalf of Mr. Booth were strongly contested in counter-submissions made by the local authority, on whose behalf it was argued that the local authority was carrying out a public function which it was required to perform by law, and that in those circumstances costs should not follow the event, but should be awarded only if the local authority had acted unreasonably or in bad faith. It was argued that the principle in the Merthyr Tydfil case should be followed. And if one goes on to paragraph 11 on page 1185, one sees there that Lord Brigham refers to the Merthyr Tydfil case. And he quotes, goes on to quote from the judgment of Mr. Justice Lightman in that case. And if one goes over to page 1186, at paragraph 13, one sees in the last sentence, one sees in paragraph 13 a quotation from Mr. Justice Lightman's judgment, and the last sentence encapsulates the proposition that the Merthyr Tydfil case stands for. It seems to me that no order can properly be made against the police simply on the basis that costs follow the event. The Crown Court can only make such an order if it can be shown that the police's position has been totally unreasonable or prompted by some improper motive. And then on paragraph 22, on page 1187, we see the second sentence. Lord Bingham rejects that submission, or that principle. He says, on the other hand, in my judgment, the submissions made by Mr. Blair Gould on behalf of the local authority go too far the other way, since to give effect to the principle for which he contends would deprive the justices of any discretion to view the case in the round, which is, in my judgment, what Section 64 intends. So the notion that the principle as now formulated has existed for 4 decades is simply not correct, because it's actually an approach, or an approach very close to the approach that is now proposed, was actually rejected in terms by Lord Bingham in the Booth case. And as Mr. Brearley has shown you, Lord Bingham goes on to both to consider that the possibility that success may suffice without any additional good reason for granting the appellant their costs. And he does so in paragraph 25, and in paragraph 26 he adopts a expressly multifactorial approach. Now, one point that perhaps has not been overlooked, but one is important not to overlook, is also what Lord Bingham said in paragraph 27 on page 1188. And what he says there is that he says in terms that had the outcome not been agreed, because it was a test case, in other words, everybody agreed that the appellant would keep their costs, he says he would have remitted the matter back to the magistrates for determination of the appropriate costs outcome. He says that in the third sentence, the ordinary consequence of that conclusion would be to remit the case to the justices for further consideration. And that's rather important in our submission because it reveals Lord Bingham's view as to which court should be making the evaluation here, not the appellate court, but the specialist tribunal that is more expert in the area and better placed to evaluate the various factors, including the two that he identifies. And we say it is quite instructive to stand back and compare Lord Bingham's approach to the approach that is adopted by the Court of Appeal below. And one can see just how far things have drifted away from his approach. And one sees at least 4 differences. First of all, under the principle as now contended for, one of the factors mentioned by Lord Bingham, the chilling effect on the regulator, has been elevated from a factor and turned into an inherent justification for a particular default position. Secondly, it has stripped the specialist tribunal of a large part of its discretion to decide what the proper approach to costs should be. It's being told what the starting point must be. Thirdly, it has confined the first factor that is mentioned by Lord Bingham, which is financial prejudice to the appellant, to a rather narrow conception of financial hardship. And even if established, that may or may not displace the default position. And the fourth and final difference is that similarly, all other factors are similarly only relevant if they are sufficiently weighty to amount to a good reason to displace the starting point. And we say that is to have drifted dangerously far from Lord Bingham's original approach in Booth, and dangerously close to the approach that he rejected in the Merthyr-Tydfil case. Now, may I take you next to the JISC case, which is the earliest case in the CAT to consider this. And Mr. Brearley also took you to it, but I wish to draw your attention to some additional paragraphs. It's in the authorities bundle at page 1245, where I'd like, well, it starts at 1233, and I think one can pick it up at 1245, where Sir Christopher Bellamy cites Lord Bingham in Booth, and over the page at 1246, he identifies his conclusions. And at paragraph 49, he notes that while success is a relevant factor, it may not be decisive, and that there is no formal costs follow the event rule in the CAT, and that issue-based costs orders may be more appropriate. That's what he says in paragraphs 50 to 51. Mr. Brearley took you to paragraphs 55 and 56 already. I would like, and to 57, I would like, if I may, also to draw your attention to another paragraph that we say is particularly important, and that is paragraph 58. It's on page 1249. And what Sir Christopher Bellamy says there is this. He says, "We think it would not be proper at this early stage to fetter our discretion by adopting a general principle to the effect that if the director loses, he should be liable to pay costs to a private party only if he has been guilty of a manifest error or unreasonable behaviour. Booth's case indicates that such a rule is not, as a matter of law, required. To introduce such a rule in the context of the tribunal could in itself be a disincentive to exercising the right to appeal, with possible detriment to the competitive process in the market." And that last phrase in our submission is very important, the possibility of detriment to the competitive process in the market. And it is a phrase that is not analysed by the Court of Appeal below in this case. And I would like, if I may, to dwell a little on why we say that deterring the bringing of appeals would lead to the possible detriment of the competitive process in the market. And the reason is essentially this, that the sorts of decisions that the CAT takes often have ramifications both for the future conduct of party on the market of not only the particular parties involved, but also far more generally. Infringement decisions of the CMA, although they are administrative decisions, in many ways resemble judgments. They typically contain sections that set out the CMA's interpretation of the law, as well as, of course, setting out the economic approach and applying them both to the facts. And the decision of the CMA in this case is a case in point. It contains many pages setting out the CMA's view of the law. For your notes, that you'll find that in the bundle, for example, many pages purely on the law, between pages 888 to 894 of the decision. And we submit that such decisions are, in substance, precedent-setting. Now, my learned friend in his statement of case at paragraph 104 takes issue with that characterization, and he observes that they are not technically precedents because they are made by an administrative body and not by a judicial tribunal, and so there's no obligation that they should be followed. But the reality is that such decisions come to form part of the general corpus of authority on the basis of which competition law is generally understood in this jurisdiction. One can certainly expect that the regulator will follow its previous approach in subsequent decisions. CMA decisions are routinely cited in competition law textbooks alongside judgments of the courts and alongside also equivalent administrative decisions of the European Commission. And of course, following Brexit, one would expect that the importance of domestic decisions will become only more influential. Regulators' decisions will be taken note by lawyers, by in-house counsel, and other advisors. They will influence the content of compliance training, and all of this will flow through to an understanding of business, the understanding of businesses operating in the market, and ultimately to their conduct on the market. They will inform their understanding of what business activities are legal and which are not legal, and where there are risks. And in this sense, these sorts of decisions are very far removed from the sorts of individual decisions that one sees where the police confiscate money, or where the SRA brings proceedings against a solicitor, or vehicle licensing decisions. Those will almost always be highly fact-specific. Only rarely will they have those decisions have wider ramifications for other persons than those that are not their addressees or closely connected to their addressees. And if one wants a good example of a precedent-setting decision, one doesn't need to look any further than the decision in this case. Because the approach of the CMA to determining excessive pricing would have permitted it, in effect, and by way of crude summary, to look only at whether the dominant undertaking was pricing at a significant amount above cost plus, and to not pay regard to the pricing of direct comparator products that had been alluded to and brought to their attention by the addressees of the decision. And the correction of that approach by the courts was indubitably precedent-setting and has already made its way into the leading textbooks. Now, if these sorts of decisions are not challenged on appeal, then ex hypothesi, they will stand unchallenged. And that is something that is liable to harm not only the addressees of the decision, but also the competitive process on the market more generally. They are what is called in the jargon of antitrust or competition law false positives or type 1 errors. that by condemning potentially beneficial practices are liable to operate against the public interest. Now, I also, we've referred in our written case to an article, a classic article written by Professor Easterbrook of the University of Chicago in the Texas Law Review. For your note only, it's at pages 3534 and following. And Professor Easterbrook's general thesis is that it is inherently likely to be more harmful to prohibit beneficial business practices than it is to prohibit harmful business practices, because he says the market will
prohibit harmful.
Forgive me, then to not prohibit harmful. Forgive me, to not prohibit harmful business practices, and that's because he says effectively the market will be is ultimately in the long run self-correcting. Now, I don't, of course.
This is Chicago economics.
Yes, my lord, it is. Now, I don't expect for one moment this court to adopt one or other.
CMA out of a job.
Yeah, indeed. But the only point I make is that there is a clear cost of false positives if they are not corrected. But of course, false positives will only be corrected if appeals are actually brought.
Well, and there's a shorter point, isn't there? Apart from the precedential effect, you might say that it distorts competition if somebody's found to have a dominant position or to abuse it when they don't.
Well, indeed, even in that individual instance,
yes.
Even beyond, yes, indeed. And it's both types of effect that, of course, potentially affect a wide number of people and are a matter that needs to be considered in the public interest.
I don't wish to set another hair running, but I'm not sure we've got in the cases a case, what the CAT does about costs when a complainant challenges a decision by the CMA not to open an investigation. That's where is there any I know they don't often happen, but where they do happen, if the CAT upholds the discretion of the CMA not to open an investigation, that might be another area where one wouldn't want to chill the ability of a complainant to challenge the CMA's decision to agree with the alleged infringer that there's nothing here to investigate.
Well, indeed, my lady, I can't think of a case precisely on clause with that, but we will do our research as well. I mean, there is the IBA Health case where there was a successful challenge to a decision not to refer a merger, which is by a complainant, a third-party complainant. But I can't think off the top of my head of a case. Of course, there is an administrative discretion that the CMA has to whether to pursue infringement decisions, which can also be invoked as a reason for not opening an investigation. If I may, it's also important in our submission to bear in mind that even unsuccessful appeals can, in fact, bring about useful clarification of the law in the public interest. And a number of recent examples of those sorts of clarifications are actually given in the written statement of intervention by the Association of the British Pharmaceutical Industry and the British Generic Manufacturers Association. Again, for your note, it's in the bundle of key documents at tab 5 at page 161, paragraphs 29 to 31. And perhaps we could, if I could, just show you some of that. Again, it's in the key documents file, tab 5, and having given a number of examples of the sort of useful clarification that unsuccessful appeals have brought. It's at page, one can see at paragraph 34 at page 163. they observe this. They say this: in reality, many, if not most, Section 46 appeals create what amounts to substantial new law, or at least shows how the law applies to particular factual scenarios which may be common in the relevant industry. That has been the experience of the farmer associations in the sector with which they are most familiar. Such developments have a real impact on business decisions that are made every day. And paragraph 36 on the next page, they say, in a complex and developing area such as competition law, the iterative process of initial decision-making and appeal leads to greater clarity in how the law is to be interpreted and applied, giving those who are subject to it greater confidence in its application and leading to more effective compliance and better enforcement.
One can't press this too far because every appeal to this court has to have an element of public importance beyond the interest to the parties, but nonetheless costs tend to follow the event. So what's the difference between this situation and...
No, well, indeed, but that is why costs should follow success in our submission, because one does not wish to deter meritorious appeals. And the point that is made here is that even when an appeal is unsuccessful, it in fact can have a side effect.
You're relying on this to cancel out any chilling effect, as it were, so that you get back to where it just leaves it to the normal sort of approach.
Well, that's one way of putting it, my lord, yes. Yes. But we do say that businesses have to make rational commercial calculations. They have to say to themselves, well, is it better to fight a decision that one considers to be erroneous, or is it better simply to roll over and settle? Now, I don't have the precise figures, but it's inevitable that the total costs, say, to my client, Flynn, that it has already expended in challenging the fine at both the administrative stages and on appeal, are not far off the amount of the original fine itself. And
wouldn't that be a good reason for making some other order for costs, if those facts were proved? So, for instance, in the Ping case, the amount of the fine was roughly the amount that it would have cost to set aside the fine. Wouldn't that be a good reason?
Well, my lord, it's why we say it's very important that in these kind of cases, costs should follow success. Because if a party such as, take my client, for example, if they think, if one goes back ex ante to the position where they're deciding, well, do we fight this, or do we just settle at a very early stage? And if they're told, well, if you fight this, you're going to spend £3 million fighting for this over this £5 million fine, but you're not going, even if you win, you won't get a penny of that £3 million back, and you still might have to then face another administrative phase where it'll be remitted, and you still won't be able to get a penny of that back either. Now, in those circumstances, it becomes very difficult to justify appealing, and it becomes much more attractive just to roll over and settle, even if you are convinced that the decision is erroneous.
What's stopping you appealing and then explaining all that to the tribunal and saying that's a good reason?
Well, my lord, we say that's all contingent, and that isn't going to. They need the comfort of guidelines and starting points. My lord, if I may briefly refer to some of the High Court cases. Baxendale Walker has really already been dealt with by Mr. Brearley. It said in the Court of Appeal considered that the Court of Appeal in the present case considered that the Court of Appeal in Baxendale Walker had effectively approved the statement of Lord Justice Moses in the divisional court below. And that statement of Lord Justice Moses essentially reflected the Merthyr Tydfil approach that Lord Bingham expressly rejected. a default rule of no order as to costs save for unreasonable conduct. We say that is not a fair, correct reading of the judgment of the Court of Appeal in Baxendale Walker when you look at it as a whole, and we refer in particular to paragraphs 34 to 39 of Lord Justice Judge's judgment, which we say is very much based on an analysis of the particular substantive, legislative and procedural context, and as Mr. Brearley has shown, on a real-world potential chilling effect. And we find ourselves comforted that the SRA appears to consider that to be the case as well, as indeed did the Court of Appeal in BT and Ofcom, where at paragraph 68, that Court of Appeal noted that Baxendale Walker is limited what it said to the solicitor's disciplinary context. We've referred in our statement of case to a number of the other CAT cases at paragraph 63 to 72. Time does not permit me, nor would it be appropriate to go through those. Mr. Brearley has already taken you to the RBS Backhall case, which shows that the chilling effect was very much taken into account on the regulator in that particular regulatory context, and was regarded as decisive and sufficient for a default position of no order as to costs. But there are also many other cases before the CAT in other regulatory contexts where one sees the CAT taking a different approach, but nonetheless also typically taking into account, at least in the original cases, taking into account the effect of chilling effects on both ways. And any notion that in appeals against infringement decisions, the CAT was formally applying a costs follow the event rule in the sense of the CPR equivalent was actually formally scotched by the Court of Appeal in the Quamby judgment. Again, for your note, you'll see that at page 1257, and in particular paragraphs 20 to 24 and 30 to 34. Could I come next, please, to Perrin Panathan? And I'd like to make some additional points in relation to that judgment, in addition to those that Mr. Brearley's already made. You'll find it starts at page 1267. And the first point I'd like to observe is paragraph 1 of the judgment of Lord Justice Stanley Burnton on page 1269. What one sees is, in the final sentence on that page, is that the claimant challenges both the correctness of the decision of the divisional court in Bradford and Booth, and, if the principle enunciated by Lord Bingham in that case is good law, its application to proceedings under section 298, and in particular the present case. So this was a full frontal assault on Lord Bingham's three principles in Booth, effectively saying there should be a structured costs follow the event rule. And that's important because it's what framed the debate. And if one then goes forward to page 1275, at page where one sees that the principles in Bradford are set out in paragraphs 13 and 14. And over the page, if one goes to 1277, paragraph 19, we see that the starting point of the analysis is a consideration of the statutory provisions, and in particular the procedural rules as to costs. And Lord Justice Burnton notes in paragraph 19 that the procedural rule in that case does not provide any steer or indication to the court that costs should follow the event. But in the present case, of course, there is a steer, a very clear steer in the rules that costs can follow the success on an issue, and also, of course, that the parties should not be placed on an unequal footing. And if one then goes forward to paragraph 40, one sees, which is on page 1291, one sees in Lord Justice Burnton's summary the critical proviso in his third proposition in the middle of the page. He says whether the principle should be applied in other contexts will depend on the substantive legislative framework and the applicable procedural provisions. So it is not, expressly not, a universal default rule. It is one that may or may not apply depending on the circumstances. Now, one point that I would note from this paragraph 40 is that there's some slightly confusing nomenclature that's introduced, and I suggest might have led to some confusion in the later cases. Because what we see is that Lord Justice Burnton refers to the principle in the Bradford case, and the way he uses that is, we see in his subparagraph 5, is to refer to a situation, he says, where the principle applies and the party opposing the order sought by the public authority has been successful. In relation to costs, the starting point and default position is that no order as to costs should be made. And I say that I think that it is, in our respectful submission, a misnomer to say that that is the the principle in Bradford. Because Bradford, as one has seen, is clearly a multifactorial approach. It's not a default rule of no order as to costs. And one can see that Lord Justice Burnton is not himself confused by that at all, because one sees his very careful carve-out in his, that I've already shown you in subparagraph 3, where he says it all depends, whether it applies, all depends on the legislative context. And one also sees that from his agreement in paragraph 45 with what Lord Justice Goldring said in the divisional court. Because on page 1292 we see he says, I therefore agree with what was said by Lord Justice Goldring in the divisional court. And as Mr. Brearley has shown you, one of the things that he then agrees with is what Lord Justice Goldring says at paragraph 32 of his judgment, which he quotes, which is that it's important and necessary to emphasize the limits of what is said in the Bradford case. The Bradford case merely sets out a series of factors which the court should take into account. So Lord Justice Burnton is not in any confusion, but I suggest respectfully that his use of the phrase the principle in Bradford as shorthand for a default rule of no order as to costs may have caused confusion in subsequent cases. And as regards Lord Neuberger's judgment, we say that when one looks at it in the round, it is not plausible that he was seeking to somehow depart from the approach of Lord Justice Goldring or Lord Justice Burnton. We see that he pays careful attention to the legislative context, and at paragraph 53 to the allegation of a chilling effect. And we also see that we've also seen that he regards his judgment as largely consistent with that of Lord Justice Burnton, and of course, Lord Justice Kay agreed with both judgments. Now, it's true to say that in paragraph 76 of his judgment, Lord Neuberger says that in a case where regulatory bodies carry out regulatory functions, and have not acted unreasonably in opposing the grant of relief, there should not be a presumption that they should pay the other party's costs. But we make a number of points about that. First of all, it was clearly an obiter dictum, as the Court of Appeal in BT and Ofcom rightly pointed out at paragraph 69. Secondly, although he's saying that there is no presumption that they should pay costs, equally he is not saying that there is any formal presumption that there should be no order as to costs. And we respectfully suggest that it is unlikely that Lord Neuberger intended to mean that there should always be a starting point of no order as to costs, regardless of the legislative context or the plausible existence of any chilling effect on the regulator. Because to do so would have been to propose a far more rigid position than that adopted in the prior judgment of Lord Justice Burnton, which, as you've seen, expressly conditions the application of the no order as to costs default on the particular legislative context. And it would also, of course, be difficult to square with his approval of the 3 principles of Lord Bingham, which he expressly cites and agrees with. So we say it's a mistake to read Lord Neuberger's judgment as though it were a statutory text, particularly on a point that is not an issue. So that's what we have to say about Perrin-Panathan. If I may briefly also go to the Katz judgment in Eden-Brown, which was an appeal on penalty. And first of all, to note what the Court of Appeal says about that judgment. It says about the Eden-Brown judgment at paragraph 87 that in Eden-Brown it said it was held that the principles established in Bradford, Baxendale, Walker and Perrin-Panathan had no application to infringement cases. And we would suggest that that actually is not a wholly fair summary of Eden-Brown. And if I could show you the judgment, it's at starts at page 1212. And the basis for the Court of Appeal's summary one sees in paragraph 16, which is at page, starts at page 1221. And it's actually, it starts at page 1221, and the relevant passage is at 1222. And what the chairman says is, he says, in our judgment, the approach set out in the City of Bradford case, as considered and explained by the Court of Appeal in Perrin-Panathan, should have no application to an appeal before this tribunal against a decision of the OFT finding infringement and imposing a penalty. Now, we suggest that actually, when he's speaking of the approach set out in the City of Bradford case, as considered and explained in Perrin-Panathan, he is using that expression with a nomenclature that Lord Justice Burnton has adopted in paragraph 40 of his judgment. In other words, all he is saying is, in our judgment, there should not be a default rule of no order as to costs. He is not saying there that the considerations, the factors underlying those judgments are irrelevant to the CAT. And one can see that because if one goes back in the judgment to paragraph 8 on page 1217, he records the arguments of the OFT in paragraph 8. And he says the OFT contends that the starting point should be that costs should fall where they lie. And he notes in paragraph 10 on page 1218, he says this: we do not consider that having this principle as the starting point should deter the OFT from imposing appropriate penalties. The OFT does not contend that its potential liability for the costs of a successful appeal deters it from taking decisions finding infringements of the 98 Act and Articles 101 and 102 to FEU. So he is expressly considering the chilling effect, and he is stating his view that there is none. And that is actually a perfect application of Lord Bingham's approach, not a deviation from it. Now,
in fact, from what we saw from Mr. Brearley is that it's entirely neutral in terms of money for the CMA, because they don't get to keep the penalties that they impose beyond the cost recovery.
My lady, that's absolutely correct as to the position now.
Yeah.
I don't think we've yet got to the bottom of whether that was true of the OFT at this time as well.
I'm thinking of the
and I don't know whether the financial situation was brought to the attention of Mr. Justice Roth. But the point that we would just take from this is that he is considering he is considering effectively the Bradford principles, plural, because he is considering whether there's any chilling effect. And he is clearly more than sceptical about that. And he considers also a number of other factors, all in their legislative context. Now, the CMA says, well, this is unfair because, in fact, we didn't make any concession, or we didn't, it's not correct what he says in the second sentence of paragraph 10, that the OFT didn't contend that it might be deterred. But that is really nothing to the point. The point is that the judge considered it for himself, and he was not convinced that there was any chilling effect. And if one steps back, for all the reasons that Mr. Brearley has given already, it's just not plausible that there is a chilling effect on the CMA, even leaving aside the telling factor of its ability to deduct the costs, because to deduct costs from the penalty recoveries that it makes. I mean, the CMA is a highly specialized, well-resourced, sophisticated organization with a large budget, as we've seen, and it selects its cases very carefully on the basis of administrative priorities. It reaches its decision after a long, in-depth, careful investigation, and it appoints an independent case decision group to consider the merits of the case. And that decision group shouldn't allow the case to go forward unless it considers that there is cogent and clear evidence to support the decision. It makes little over half a dozen infringement decisions a year. And if one steps back and asks, is it really plausible that the CMA would come to the end of an infringement decision and then say, well, actually, maybe we better not take this decision because we're worried that if it's appealed, there will be an adverse costs order? The answer is that is just not remotely plausible. And the situation is completely different from policemen making confiscation orders, or even the SRA bringing disciplinary cases against solicitors. The SRA notes in its submission in intervention at paragraph 7 that it brings about 120 to 130 cases a year. Now, one can at least see a respectable argument that if the CRA faced adverse costs awards, it might tend to concentrate on the low-hanging fruit and avoid the difficult cases. I don't say that that's correct or not, but I can at least see an argument to that effect. But I don't see a plausible contention to that effect when it comes to the CMA. And if there is no deterrent effect, then we say, as I said at the outset, that the public policy rule that is supposed to justify this becomes entirely detached from the rule that is then imposed. And that's not desirable. Finally, I come to BT and Ofcom. And the key point that we say is germane to the present appeal is that one can't actually get from the Court of Appeal's judgment in Ofcom the principle that is contended for by the CMA and adopted by the Court of Appeal in the present case. And one sees that very clearly in the final paragraphs of the judgment, and in particular in its last sentence, that is curiously not quoted in the Court of Appeal below. Because what the last sentence makes clear is that the Court of Appeal in Ofcom remitted the matter back to the CAT for reconsideration of not just the appropriate order as to costs, but also to decide the appropriate applicable starting point as to costs. And it was the CAT was to decide that starting point based upon the arguments as to the chilling effect advanced by both sides. So in doing that, the Court of Appeal in Ofcom recognized that where there are both potential chilling effects, both on appellants and on the regulator, it's important for the specialist tribunal to be allowed to seek to evaluate their relative potency and their importance to the public interest. And that specialist tribunal should then determine the appropriate starting point. The Court of Appeal in Ofcom didn't take that starting point as predetermined, and that is inconsistent with the approach of the Court of Appeal below. Now, as to what the precise ratio of BT and Ofcom was, one does see that the thrust of the reasoning is in paragraph 72 to 78, and that was that certain of the CAT cases that it had considered, notably Tesco and PayTV, had not taken account or had not taken adequate account of the authorities following Bradford, and hence of chilling effect factors. Now, whether or not the Court of Appeal was right or wrong to allow that appeal on that basis is a matter that this court does not necessarily have to determine. But we do note that the judgment in PayTV itself does appear, to us at least, to contain some consideration of the factor of a potential chilling effect on the regulator. And you'll see that for your Lordship's notes, that's paragraphs 15, 25 and 52 of the PayTV judgment, which you will see at pages 1841, 1848, 1852 and 1861. But in any event, right or wrong, that judgment has got little bearing on this case. The CAT in JISC and which was a seminal case, had the chilling effects well in mind. It took them into account and reached a reasoned starting point in light of them. And the CAT in this case was entitled to follow that judgment, as well as Eden Brown. And there was no basis for the Court of Appeal properly to disturb that assessment. And that is particularly so, of course, when all the CAT did was to apply an issue-based approach.
The principle or the comment of of the Chancellor in BT and Ofcom, that it doesn't really matter by what route the issue comes before the CAT. Do you accept that, or do you challenge that?
Not entirely. It's fair to say that in BT and Ofcom, it appears that the case was argued on the basis, it seems, of a number of quite fine distinctions as to the precise way that the regulator came before the CAT. And one sees that recorded, as your lady says, at paragraph 4. We say that those distinctions may make a difference insofar as they correspond to the potency of the two chilling effects, or are otherwise relevant in some way. But they are not, as it were, in and of themselves relevant. They are relevant if they are germane to the existence of chilling effects, or to some other factor, such as litigation discipline, or the existence of very expensive prior administrative proceedings and so on. But they're not in and of themselves a basis to distinguish. And it may be that because it was argued in that way, that is why things slightly went off the rails. I think that it may be that, I mean, one way to understand the Court of Appeal's judgment in BT and Ofcom is to say that they are saying, and it isn't put this way, and certainly isn't put so crudely, but is to say that they are saying that there is, if you like, a starting point for the starting point. And that therefore one should tend to assume that there will be a default provision of no order as to costs. We say that if that is the correct reading of BT and Ofcom, it is not correct. There's no reason to have a presumption or an assumption one way or the other. It's a matter simply for the tribunal to weigh up all the factors and come to a view. So to conclude, my lord, my ladies...
come to a different view,
yes,
depending on the particular nature of the jurisdiction.
Yes, indeed, indeed, indeed. It all depends on the regulatory and legislative context in our submission. So we say in conclusion that the approach of the Court of Appeal below might spare the public purse, at least in the short run, but it is not an approach that is likely to serve the public interest. There is space, we say, for an approach that is more tailored to the particular regulatory and legislative context, but which also, by providing guidelines, maintains predictability for litigants and for the tribunal itself. And importantly, that approach will ensure and take full into account that appeals should not be deterred and that erroneous decisions should be appealed and corrected. And we say that the CAT's approach to infringement decisions first set out in the GIST case achieves that and remains faithful to the principles and the spirit of Lord Bingham's judgment in Bradford. My Lord, unless I can assist the court further, those are our submissions.
Thank you very much. Mr. James.
My lords, my lady, a competition authority, said Lord Zumption, is not an ordinary litigant, but a public authority charged with enforcing the law. We respectfully agree. That was the statement that Lord Zumption made in the Gallagher case at paragraph 46, page 3055. What I wanted to do, if I may, and if it wouldn't overburden the court, is to go back through the usual run of cases just to make sure you've got everything 3 times over in relation to the 4 key cases. But I hope I won't dwell too long on the bits that you've already been shown. And then to try and distill from that case law what we respectfully submit are the 6 key propositions of principle that are to be derived from them. And then probably tomorrow to deal with some directly responsive points, if that's an acceptable structure. So the cases, first of all, and in order of time, May 2000, Bradford and Booth. That is dealt with by the Court of Appeal below at paragraphs 20 to 22, and you have it at page 1181 on the electronics. And the features to bear in mind in relation to this case we submit, the facts are well known, are as follows. Firstly, as the court pointed out, and as the court noted at paragraph 6, the relevant cost power, which was the same cost power that was being considered in Perrin Panathan, was section 64 of the Magistrates' Courts Act 1980, and it contained no rule or principle or reference to the idea that costs should follow the event. It was effectively open-ended and enjoined the court to make such order as to costs as it thinks just and reasonable, pure and simple. And in those circumstances, the issue grappled with by the court collapsed into the two questions that you see recorded at paragraph 9 of the judgment, towards the bottom of page 1184, to which Lord Bingham then gave the answers at paragraph 27 at the end of the judgment. But you will note the submission that was advanced by the local authority in that case, recorded at paragraph 10, which was in effect a plea for a rule that there should never be an award, underlining never, there should never be an award of costs against the local authority unless the local authority had acted unreasonably. It was that proposition that was rejected, and it is right to acknowledge that that appears to have been quite close to the approach adopted by Mr. Justice Lightman in the Merthyr Tydfil case that is cited between paragraphs 11 to 14. See in particular the final sentence of the quotation set out in paragraph 13. An absolute rule with no exceptions, no order can be made unless it can be shown totally unreasonable, prompted by some improper motive. It was that which was rejected. However, you will also note the passage to which neither of my learned friends took you from the judgment of Lord Justice May in the next case which Lord Bingham cited and relied upon, and we respectfully submit in effect adopted, namely the Chief Constable of Derbyshire and Goodman case, the citation of which starts at paragraph 15 on page 1186. That was a firearms licensing case. Their decision, the police's decision, was revoked following appeal to the Crown Court, which had ordered costs against the police. That was overturned by the Divisional Court. And the Divisional Court, as you see from the quotation from Lord Justice May's judgment at paragraph 18, the Divisional Court concluded that it was necessary to take the fact that they were performing a statutory licensing function into account, and that an order for costs should not be made unless, see the penultimate line of the quote in paragraph 18, there was some good reason for doing so. Again, a familiar structure, starting point, unless there is some good reason, not limited simply to a rule which is unreasonableness or impropriety of motive. And that citation from Lord Justice May then led directly into the rejection of the local authorities' extreme position, never unless unreasonable or improper motive, but also a rejection of the idea that costs should follow the event, pursuant to that general and open-ended section 64 that they set out. And you see that rejection in paragraph 22 that was indeed the basis on which they held that the justices had been wrong and had been in error. And we emphasise that point because despite repeated submissions by both of my learned friends today that what they're actually advocating for in relation to booth and all things subsequent to booth is a factorial approach, what in truth they are arguing for, as became evident by slippage if nothing else, what in truth they're arguing for is a success-based rule. Ultimately, what they want is a rule that costs follow the event. That is the starting point which they seek to achieve, and that was specifically rejected as an appropriate starting point, specifically and expressly rejected as an appropriate starting point in relation to an open-ended cost provision such as Section 64, which doesn't contain it.
I understood their position to be that you can have, as it were, a mini rule, starting point, costs follow the event for infringement cases, but or no order for costs in an appeal, regulatory appeal or something. But what you can't have is a general starting point across all categories of case, either costs follow the event or the one that you want to have, which is no order for costs if you're a public authority.
Well, my Lord, for reasons I will develop, and as you understand already from our case, our position is that this run of cases does indeed establish a starting point in a certain category of case, namely those involving regulatory proceedings. But the starting point is the more nuanced one, which is displaceable if there is good reason for doing so. And then there are examples of what a good reason is.
Why didn't Lord Justice Bingham adopt Lord Justice May's wording when he set out the principles at paragraph 26? Because he doesn't.
My Lord, he doesn't in terms. He sets out the propositions.
He uses different expression.
He uses different expression, and he does so in his own language, summarising the propositions, of which the third one is obviously key. But I respectfully submit that there is nothing inconsistent with the approach that he adopts, or there's no inconsistency between that approach and the way it is expressed by Lord Justice May. And I'll come on to develop what we respectfully submit that third proposition means and the relative importance of the regulatory function. But the third proposition is indeed the critical one, it might be thought, the one at paragraph 26.
Why doesn't Lord Justice May refer to undue financial pressure when he's articulating the concept? Because that's what Lord Bingham does.
My Lord, because my respectful submission is that he doesn't need to do that. What Lord Bingham is exploring and the expansion in Lord Bingham's propositions are to include both the nature of the rule and the rationale for it. What Lord Justice May does is to set out as the proposition, and
Justice May's proposition isn't dependent upon there being any adverse chilling effect.
My Lord, no, but the chilling effect and the significance of chilling effect, to which I will come back, is the rationale for the basic principle, which is that it's thoroughly important for the tribunal to take into account that a cost order adverse to an authority should not be made unless there's good reason to do so. So it effectively creates the presumption. And the reason for that, or some of the reasons for that, are encapsulated in Lord Bingham's third proposition. So there's no inconsistency, there's just greater explanation, is I think the answer I give to my Lord on that. In any event, it was that third proposition, just for your note, that the Chancellor in BT and Ofcom was the one that resonates, as he put it, in relation to regulatory proceedings before the CAT, and as he also put it, must be taken to be of some importance in that context. See paragraph 67 of BT and Ofcom at page 1207. we respectfully submit that it does not do justice to that third proposition to describe it simply as a factor to be taken into account in the round. It is evident that the court and Lord Bingham attached real importance to the nature of the functions being performed. And that is entirely clear because the weight that they attached to that feature, namely the nature of the functions being performed, was so weighty that they displaced any idea that costs should follow the event. We do also invite you to note the way in which, I mean, again, one shouldn't be reading the judgment necessarily as a statute, but it is Lord Bingham. We invite you to note the way in which he puts the rationale in paragraph 26 by reference to the need to encourage public authorities to make and stand by honest, reasonable and apparently sound administrative decisions made in the public interest without fear of exposure to undue financial prejudice if the decision is successfully challenged. That is a principle or a rationale which is about encouragement. It's a theme I'm going to come back to in the context of chilling effect. That's how Lord Bingham chose to put it.
And undue is extreme, inordinate,
or significant, or somewhere in that range.
different from financial prejudice to the particular complainant.
Well, my Lord, I noted your point earlier that an additional adjective had been introduced by Lord Bingham in the context of the regulator rather than the regulated.
I was quite interested in how financial prejudice became substantial financial hardship in the Court of Appeal decision, in this case at paragraph 79, subparagraph 5.
Yes, I mean, it may just be that the additional adjective is recognising the position that a public authority will normally have, at least an assumption of solvency, if I can put it that way, without going too far down that road, given the state of current public finances. But that appears to be at least a possible explanation for the introduction of the additional adjective.
It might be that more regard is to be paid to the financial prejudice to a complainant than to a public authority.
Well, my Lord, yeah, my Lord, it is a factor. It is an issue, and we respectfully submit, you know, in relation to the principle that we respectfully submit is the right one, that is possibly the paradigm example of a good reason. That approach by Lord Bingham was then applied by the divisional court in. Can you get me Nestling up on the screen? Page 2935. Was applied by the divisional court of Lord Justice Richards and Mr. Justice Toulson, with the judgment being written by Mr. Justice Toulson. Nestling is at 2935. And I wanted to invite the court to turn to and just see how Mr. Justice Toulson put the point at paragraph 11 on page 2938. And then paragraph 12, if you would, as well. Which may bear on the point that my Lord Stevens was putting to me a minute ago, paragraph 12. But you see how he puts it at paragraph 11, which we respectfully submit is entirely consistent with our analysis of Lord Bingham in Booth, rejecting the rule, the Merthyr Tydfil rule, but nevertheless acknowledging the importance of unreasonable conduct to matters of that kind, but fundamentally emphasising the function and position of the regulator or the local authority exercising public functions. So that is Booth and the cases that preceded Booth, and then Nestling. The next in order of sequence, I think, is Baxendale Walker. That's at 1169. That's March 2007, dealt with in the Court of Appeal below's judgment between paragraphs 23 and 28. And it, in effect, applies that approach into the regulatory sphere, here solicitors' disciplinary regulation, and further analyses how the approach should operate. Again, the facts are evident from paragraph 1. There were disciplinary proceedings before the Law Society Tribunal. The cost ruling was overturned by the Divisional Court, and their cost ruling was upheld by the Court of Appeal. That's the Divisional Court's cost ruling. There was here, as in Booth, what might be described as an open-ended empowering provision, as one sees from paragraph 27 on page 1176. And in essence, the Divisional Court upheld the reasoning and approach of Lord Justice Moses below, the key part of which is at page 1177. Set out at the end of paragraph 29 in the Court of Appeal's judgment. You'll see how he puts the principle, absent dishonesty or lack of good faith, a cost order should not be made against such a regulator unless there is good reason to do so. The reason must be more than the other party succeeded in considering an award of costs against a public regulator. The court must consider on the one hand the financial prejudice to the particular complainant, weighed against the need to encourage public bodies to exercise their public function of making reasonable and sound decisions without fear of exposure to undue, my Lord will seems to be pleased to see that word in Lord Justice Moses' judgment, undue financial prejudice if the decision is successfully challenged. So that was how Lord Justice Moses approached matters, and that was essentially upheld by the Court of Appeal. But here, the Court of Appeal were specifically addressing the issue of principle as to the correct approach as to, in effect, the weight of the point that the person is acting, or the regulator may be acting, in the exercise of a public function.
But the weight to attach to that point depends on the likelihood that the public body will be deterred in a particular context by orders for costs against it. It doesn't have any independent weight. It's not a principle like the principle of fairness that if you win the case you ought to get your costs. There's no intrinsic reason why it's fair to not to have to pay the other party's costs if you lose. It all depends on the likely consequence of such an order, and that depends on the facts of the situation.
My Lord, to some extent I accept that. There is, I'll come to chilling and all things to do with chilling in a moment when I pull together the core propositions. There is at least some suggestion, not least in the judgment of the Court of Appeal in which my Lord sat, so I'm wary about going too far and too fast down this road, but there is some suggestion that the principle would be engaged in any event, and was engaged in the Court's view in any event in BT and Ofcom, irrespective of the nature of the outcome of the referral. which suggests that there is some intrinsic importance attached to the fact, from a cost perspective, to the fact that the person is indeed acting as a public, in pursuit of public functions. But when I get to it, I will be submitting principally that, in line with the analysis of Lord Bingham and in the subsequent cases, the chilling effect needs to be thought about as comprising at least two different related elements, the first of which is the encouragement point, the encouragement to make decisions without fear or favour, because that strongly serves the public interest. And the second of them might be called the purer form of chilling effect, where they are actually deterred, or might be actually deterred from making decisions. Now, of course, that they are, to some extent, closely interrelated, those 2 points, but they are at least separate features. So I don't entirely accept the thrust of my Lord's point, although, of course, I accept the majority of it. There's much less of an intrinsic value in simply saying a public authority is pursuing public functions.
Well, there's also a difference between a public authority and a regulator.
There is.
Ofcom is a real regulator, and it has a regulated community, and those members of that community have to deal with it and are often in front of the CAT challenging its decisions. But the CMA isn't a regulator. I mean, it's not regulating the pharmaceutical industry. They have their own different regulators. It's not licensing them. It's enforcing statutory prohibitions.
My lady, that is of course true, but I respectfully submit that that doesn't divorce it from properly being described as a regulator in that sense. There are many regulators who regulate on the basis of statutory rules.
Yes, but they usually have some kind of authorising function, and they have, like, Financial Conduct Authority, it authorises people, and those are the regulated community. But the community that's regulated by the CMA is every possible undertaking. It's not some subset of people who are particularly within the remit of the CMA.
My lady, again, I accept that.
So it's a public body.
I accept that, but it is a public body performing those sorts of regulatory functions, making the same sorts of decisions that Ofcom would have to make about whether to go with a particular decision, whether to seek to defend it in subsequent contested litigation before the self-same tribunal. It is no accident that CAT sits atop both. They are performing, for this purpose, we respectfully submit, essentially the same function. But perhaps a prior answer to my lady's point, I don't want to lose that point because it's an important one. I respectfully submit that there isn't, for present purposes, a distinction between, for example, Ofcom and what the CMA are doing. But a prior point, it might be thought, is that in relation to both Booth and Perrin Penathanen, as you're aware, the body to whom the principle was applied was the police. And the police exercised an entirely open-ended, if that was the thrust of my lady's question, which I think it was, in fairness, they exercise entirely open-ended functions in relation to the totality of the population. They don't have a regulated community in any real sense. So perhaps the principal way of answering my lady is that the principle we submit applies and has been described as applying to those who are exercising, like local authorities, the same. Local authorities, the police, those who are exercising public functions in the public interest, and regulators, or if you wish to distinguish in detailed terms between Ofcom and the CMA, quasi-regulators, are simply species of the breed.
I understand that your public function chilling effect is broken down into two categories. That's encouragement without fear and favour, and the second one, which is, as I understand it, the pure economic chilling effect. And do our public servants need to be encouraged in that sense? And does that ignore the discipline of actually not being overly encouraged?
Well, my Lord, I respectfully submit that the answer to the question is provided by the case law. This long line of case law evidently considered that those who were the subject of the favourable decision, the police, the local authority, the law society disciplining body, Ofcom.
That's by the chilling effect, presumably, of the financial consequences, but surely they're public servants and getting on with their job.
My Lord, of course, and they can be expected, no doubt, to do that.
Yeah.
But that is not inconsistent with there being a benefit in public interest terms in the encouragement of the more favourable cost position. I mean, take an example in a pure regulatory context. You have a regulator who is considering making a decision which might have significant public interest effects, but it is novel or controversial, or likely to be so. And they're likely to be faced, if they do take that decision, with a battery of highly paid lawyers employed by rich companies. Of course, one can expect them to hold firm to some degree, but it is the encouragement part goes to try and make sure that they are put in a position which is relatively favourable to ensure that they make decisions without fear or favour.
The thing is, it proves too much, that argument, because then every judicial review case it would operate, wouldn't it? I know you say, well, there's a different rule in the CPR, but that's not really an answer, because that's just you're just falling back on there's no reason underlying that.
Well, my Lord, there is a different rule, which is the primary answer, but it might also be thought that as a sweep of decisions picked up by that specialist rule, there is, it might be thought, a distinction between the sort of situation covered by this case law and the absolute run of central government decision-making, which is challenged on grounds of lawfulness in the administrative court. There may be all sorts of different policy things that are in play in relation to the way you set up cost rules in one case as compared to another, not the least of which is that it will be very often the case in public law cases, as you're very well aware, that an individual affected by a decision will come along and make the challenge, whereas a regulated environment such as the markets which Ofcom and the CMA are overseeing are populated by what might be thought to be a different and more dangerous breed in terms of costs, at least. So I wouldn't accept that there is no distinction at the level of policy or principle between the one context and the other. But the short and complete answer, I submit, is that there is a different rule, whatever the principal underpinnings for that may be, in the CPR, in judicial review cases. The ordinary and clear rule expressed on the face of the rules themselves that are applicable is that costs shall follow the event. If you will, a deliberate legislative choice has been taken in the context of Section 64 of the Magistrates' Court Act and the Police Act and all the rest of it, all these cases, a different conscious legislative decision has been taken, which is to leave that out. That's why in BT and Ofcom the court considered and made the comment that there's no particular reason for supposing, if Parliament has chosen to leave that out, no particular reason for supposing that should be the default position or the starting point. Sorry, I was back in Baxendale Walker, if I may. We've got to the end of my submissions by the time I finish the run through the 4 cases, but at least help, I suppose, if I pull them together afterwards. But 1178, paras 32 and 33, Court of Appeal there specifically addressing the issue of principle arising as to the correct approach as to, in effect, the weight of the point that a person is acting in exercise of a public function. And then 34 and 35, obviously, of some importance. particularly perhaps that second half of paragraph 34. So they effectively approach the position in principle in 34, and then in 35 they turn to the authorities and conclude that they are consistent with the principle and confirm it. And then 39, which you've been taken to, contains the conclusion and the ratio. You'll note that the Gorloff case cited by the letter B on page 1180 was effectively the equivalent of the Law Society, but this time for chartered accountants. That's a decision of Mr. Justice Jackson, in which the same starting point was applied. The Booth principled approach was applied, but costs were nevertheless awarded because it had been shambolic from start to finish. And you'll see the twin features that are identified between letters B and D in paragraph 39. Unless the complaint is improperly brought or, for example, proceeds as a shambles from start to finish when the Law Society is discharging its responsibilities as a regulator for the profession, an order for costs should not ordinarily be made against it. That's ordinarily be made against it on the basis that costs follow the event. The event is simply one factor consideration. For consideration, it's not a starting point. Again, that rejection entirely consistent with Lord Bingham. There's no assumption that an order for costs in favour of a solicitor who successfully defeated an allegation of professional misconduct will automatically follow. And then this one crucial feature, which should inform the tribunal's cost decision, is that the proceedings were brought by the Law Society in exercise of its regulatory responsibility in the public interest and the maintenance of proper professional standards. For the Law Society to be exposed to the risk of an adverse cost order simply because properly brought proceedings were unsuccessful might have a chilling effect on the exercise of its regulatory obligations to the public disadvantage. Accordingly, Lord Justice Moses' approach to this issue, which did not go further than the principles described in this judgment. And you'll recall how Lord Justice Moses put it back in the tail end of paragraph 29 of this judgment. So all of those, but I said there were two key parts of para 39, there were perhaps three. The final one being the chilling effect point and how that is dealt with and how that is put. And we note that in neither this case nor indeed in Booth, nor indeed in Nestling, was there any suggestion that the chilling effect point, the disincentivizing point, the encouragement point, if you will, required evidence or was to be regarded as being some form of empirical issue as opposed to being something which was obvious and inherent. So that's Baxendale Walker. Perrin Panathan then 1267. And my learned friend Mr. Jowell is right to point out, and it's a feature upon which we positively rely, that this authority was indeed a full-blown attack on the fundamentals of what might be called the regulator approach. It was said that perhaps optimistically, that Lord Bingham had gone off the rails in Booth, It was said that it had all been misinterpreted. It was said that this context could be distinguished. So all of those points were run, including the root and branch attack on it. And the reason we rely upon that feature is because this is the Court of Appeal, including Lord Neuberger, addressing the issue at the level of principle. Full-blown, not just is this a bit of an extension, is this a bit of an increment. There was a full-blown principled attack upon it. And you see that, perhaps as clearly as anywhere, from the way in which Lord Neuberger analyses matters and the choice that he poses at paragraph 75 on page 1299. I'll come back to his judgment, but just note for present purposes that what he does in paragraph 75 is to say, well, here we've got a principled choice. We can jump one way or we can jump the other. And there are respectable arguments for both positions. So the question is, which one should we follow? In principle and on authority, he concludes, in effect, they follow the regulatory or public function line rather than the CFE line, the cost follow the event line. We were dealing here, to go back through the judgment, if I may, paragraph 12, you will note on page 1275 that you're dealing with exactly the same power that was being dealt with in the earlier case, section 64, same cost provision as in Booth, see para 12. That was no doubt why Mr. Keith thought it necessary to launch the root and branch attack that he did. And the court rejects the attack on the correctness of Booth and rejects the attempt to distinguish it. They consider, in particular in the judgment of Lord Justice Stanley Burnton, which, as it were, goes through the prior case law and analyses that. And that's Lord Neuberger's jump-off point, that exercise has already been done. But Lord Justice Stanley Burnton analyses the previous case law and see paragraph 19 and following, setting out all of the various cases, see para 22, 23 and 24, that you are familiar with and that you saw cited by Lord Bingham in Booth. One can add into the line of authority Uxbridge, which is then analysed at paragraph 26 and is at least to similar effect. With the majority of the court, as one sees at the bottom of page 1279, that's the majority of the court in Uxbridge, disagreeing with Lord Denning, but nevertheless sharing, as they put it in the fourth line of that quote, the considerable degree of unease in regard to the order for costs that had been made. And then then Lord Justice Stanley Burnton comes at paragraph 28 to analyse Baxendale Walker. And you'll see that they cite paragraph 29, including the quotation from Lord Justice Moses, which was ultimately approved. And then they cite paragraphs 39 and 40, which you've just seen on page 1282. Paragraph 30 is BT and Ofcom, but it isn't the BT and Ofcom that Lord Justice Leggett sat on. This is what's been referred to in the case law, and I think in the index as RBS backhaul. That's the case that is analysed from the CAT context in paragraph 30. And just to pick up some passages from the long citation from that case, if you're on page 1283 and you go within the quote within paragraph 30 to paragraph 51, and you go about 4 lines up from the bottom of paragraph 51 within that quote, you'll see Parliament has not created any presumption that in proceedings before the tribunal costs should follow the event. That's plainly right. That's plainly a deliberate legislative decision. And then you'll see the sorts of factors that are relied upon in analysing the point in effect as a regulation principle, as I've described it. You'll see that beginning, particularly at the end of paragraph 57, on page 1284, no unreasonable conduct on Ofcom's part, or other respect in which Ofcom's position is open to criticism. 58, final sentence, wider public interests, not just the private interests of B1 were at stake. 61, no one suggests there be financial hardship difficulties. And then the balance being struck. Can I just invite you to read to yourselves, if you would, paragraphs 62 and 63, within which are the concluding bits of that quotation, that citation on 1285. So again, you'll see how they put that chilling effect point in paragraph 63. On the contrary, we have some concern at this early stage under the 2003 Act that an order against Ofcom would have a chilling effect in the opposite direction by making Ofcom less resolved to defend its decisions. Lord Stevens may say they need more backbone, but less resolved to defend its decisions, or more ready to compromise when faced with claimants with market power and large financial resources. Any such pressure on Ofcom would not be in the public interest.
This statement, BT has benefited commercially from the stance which it legitimately took. I mean, BT can't win then, can it? Because if it loses, it has to pay the regulator's costs. If it wins, then you say, well, you've benefited from winning, so you don't need your costs as well because you're a big beast and you can afford to pay the costs as a price of getting the answer that you wanted. So
I suppose it does rather depend if on the facts they had benefited in that way. But if I can put it this way,
assume if they win that they've benefited, otherwise they were rather foolish to bring the appeal. Yeah. But that's not usually considered. Winning and therefore getting the benefit of winning is not usually considered a reason why not to award somebody their costs as well.
Well, I don't know. But I can accept that point with some equanimity, I think, because the passage that I rely upon is principally the explanation as to how chilling works in 63 for this purpose. I'm not here setting up to try and defend the totality of every sentence of the Cat's judgment in this case.
Say, well, the pharmaceutical companies may be disadvantaged, or other companies which succeed in an abuse case may be disadvantaged that they're left with a finding that they're dominant, and that then is a hamper to their future commercial conduct, even if they, in this case, succeed in showing they didn't abuse that position, and so aren't subject to the fine.
No, yes, but there's a myriad of different ways in which it could pan out in terms of benefit or disadvantage. Yeah, I mean, maybe that's leading into the initial sentence of paragraph 63, but whether that's right or wrong, there is inevitably a balance inherent in what we describe as the principle, which is where does the balance of public interest lie in terms of these sorts of contexts where public functions are being performed and regulation is being done. And the clear view of these cases in their totality is that the stronger public interest is in the encouragement or the preservation of full and fearless decision-making. And there are real concerns that were identified of the kind set out in paragraph 63. Just going on in Perin Panathan, para 31 on page 1285, you'll see that Lord Justice Stanley Burnton acknowledges that the CAC context is very different from the present context, but analyses the matter as a point of principle, in effect, trying to work out what the breadth of the principle is and what its underpinnings are, and reaches the conclusion that he does in that final sentence of paragraph 31. What is relevant to the present case, he says, is the decision that a public authority carrying out a public duty and acting reasonably was not required to pay the costs of its successful opponent in litigation. And then the principles that are derived, you've already seen, pulled together in the propositions that Lord Justice Stanley Burnton sets out at paragraph 40 on page 1291. I think this is the derivation, as it were, of the analysis that categorises the principle as being, as it's put in sub 5 of para 40, a starting point or default position, that no order should be made. But recognising there may be good reason for disapplying that. So it is a starting point, and you'll see that they've cited and have considered, and it may be of some interest to note that in paragraph 41, they analyse what is meant by financial prejudice to the private party.
Is there a statement anywhere of what the principle is? What's called the principle here?
Well, I think the closest you get to it is probably 40 sub 5.
Well, that's saying where the principle applies, but what's the principle that you're applying?
Well, my Lord, I think what they mean by that, Lord.
So paragraph 17, sorry.
13 on page 1275.
Well, that with respect is the lead-in to the analysis of the brief.
Yeah, it doesn't identify what principle they extract from that. I'm just wondering whether they state anywhere clearly what this principle is that from Bradford.
Well, I think, in fairness to them, I don't want to underdo Lord Justice Stanley Burnton. He's gone through the cases with some care, and in particular has analysed the Booth decision with all the inherent elements in it that I took out from it. Not a position in which costs follow the event. There's got to, in effect, be good reason for awarding costs against the regulator.
Well, that's Lord Justice May who said that. It wasn't paragraph 26. That was not the principle set out by Bingham in paragraph 26.
Well, my Lord, I don't want to go back over that debate. It wasn't expressed in those terms, and there were the three limbs to the explanation by Lord Bingham.
Yes.
But my respectful submission is that those three propositions encapsulated both what might be called the principle and its rationale.
Okay.
Anyway, you have 40 as the key pulling together of the various propositions that were derived from the case law, and then 41 specifically directed to financial prejudice.
The principle is those three paragraphs of Lord Bingham's in Bradford.
Yes, my lady, that's it appears what he's referring to if you look at the first sentence and proposition number 1. But on any faithful reading of Booth, we respectfully submit, the principle encapsulates the idea that if you are a regulator or a person performing public functions, what might be thought to be the usual rule that costs follow the event doesn't apply, and there needs to be a good reason for awarding costs against you. Then Lord Neuberger, to go on to his judgment, at paragraph 57, draws a distinction with cases such as Southdown and Grimes, where the general rule of following the event applied. And then he makes the point in 58 that there is no provision equivalent to the CPR rule in the open-ended provision that was section 64.
I mean, there are lots of different cost rules in the CPR, aren't there? There's qualified one-way cost shifting. There are different rules in some of the pre-action protocols. I mean, costs are very specifically dealt with, both in the CPR in particular instances and actually in the CAT's jurisdictions in particular instances. That's what troubles me in this, that where Parliament wants to make a particular provision as to costs, it doesn't hesitate to do so. But it hasn't done so here to introduce this starting point. That's what's puzzling me at the moment.
My lady, I'll come, if I may, to the rules in their own terms in due course, but the short answer to my lady's point is going to be that what Parliament has done in setting up the rules in this form is not to adopt precisely the point that Lord Neuberger makes in relation to section 64 in paragraph 58, not to adopt the usual starting point. Of course, there are specialist rules of a different kind, and you can do two-way cost shifting and all the rest of it in particular circumstances and make very specific provision to that. But the base starting point under the CPR, the well-known base starting point, is that costs follow the event.
But that only gets you halfway. I mean, it doesn't favour another starting point. If anything, it suggests there isn't one.
My Lord, it leaves open the position. I can take so much from the idea that they deliberately have not done that. And as one saw from the dichotomy posed by Lord Neuberger in paragraph 75, there are pretty much two games in town in relation to the starting point. One of them is costs follow the event, and the other one is that because a regulator is involved or the body is performing public functions, that is not the default position, and the default position is that the public interest favours.
Well, there's another game in town, which is the employment tribunal. Nobody gets their costs unless it's been unreasonable.
There is. So they can set it up in any number of different ways. The question is whether there is plainly significance in the absence from the relevant rule in our context of a cost follow the event thing. True it is that they have not expressly adopted, as it were, the alternative starting point, which is at no order as to costs. But my respectful submission is that what that leaves, subject to the specific provisions which are set out in 104, what that leaves is an open-ended position in relation to the starting point, and that's what we're arguing about.
What it leaves is that at the time the rules were consulted on and adopted, everyone knew what the CAT had been doing over the last however many years. Everyone knew that was different from Booth and Baxendale Walker and the other cases. There are a sort of smorgasbord of different sorts of costs regimes that are around in CPR, in tribunals generally, and this is what Parliament chose to approve. But you're going to come along. I'm
going to come on to it, but my submission is that they left open the basic starting point, just as they had done in section 64, and the introduction of some subsidiary rules does not touch that basic point. And so, I mean, my lady says, well, everyone knew what the CAT were doing or might not have been doing. We've seen from the CAT case law that there had been some flexibility about what they had been doing and what they hadn't been doing, some vacillation between one position and another, some uncertainty in that line of case law, and at least at the point at which the relevant changes were made and introduced, as I understand it, you did have, as the recent last word in terms of analysis of the basic starting point when you're dealing with a regulator, without going back over that debate, the Court of Appeal judgment in Perinpanathan. So I submit one cannot properly operate on the assumption that there was something inconsistent with the starting point which this case and all the previous cases I've been going through adumbrate. You can't start from the position that there was a deliberate decision not to use this. There was a decision, on the contrary, per my lady's question, to rely on some relatively inconsistent case law from CAT in relation to the starting point. And you'll see that, I mean, to some extent, this idea that you need a starting point, that it's all about the starting point, is then the specific subject of consideration by Lord Neuberger in paragraph 59. And he there makes, as you see, the key point that an open-ended rule, that's open-ended as to the starting point, does not mean that a court of record cannot lay down guidance or indeed rules which should apply at least in the absence of special circumstances. So the courts can and have made such general principles or starting points. And indeed he goes further and acknowledges and sets out that there is a real advantage in that, for very much the reasons that he then analyses throughout the rest of the judgment, which is that there are basically, as a starting point, there are really only the two games in town: the regulator line, which these cases go to, and the cost follow the event line. There's no getting away from that dilemma of principle, which he squarely confronts. But the reason why a starting point is desirable, and in effect needs to be added to prevent inconsistent decision-making with all the straws floating about in the wind in every case, is something which obviously troubled Lord Neuberger. He dealt with it expressly in paragraph 59, he returns to it at paragraph 64, and then he returns to it again at paragraph 74. So he's deeply conscious of that importance and significance.
Well, who makes provides the guidance in a tribunal that has jurisdiction in every single territory of the United Kingdom?
My Lord, that's a deep constitutional question. The answer to that is that it is in principle open, no doubt, to different parts of the United Kingdom to arrive at different basic rules of the kind that we see developed in this line of case law for the purpose of England and Wales. As I understand it, there isn't any case law directly on this point in Northern Ireland. There is a case which I might have to come back to tomorrow in Scotland, in which the issue has been considered but very likely. But having acknowledged that constitutional possibility, my respectful submission would be that this court, as the court of ultimate final appeal from all parts of the United Kingdom, is addressing the principal question. What is the right answer in a situation in which you do have essentially indistinguishable features with the case law that I'm taking you through? What is the right answer when you're dealing with a regulation, a system of regulation, or a system where public function is being exercised?
And what happens then when you have, for instance, BT that operate in both Northern Ireland, Scotland, and England and Wales?
Well, what happens then is that you decide, that my submissions in relation to this line of case law are thoroughly well-founded and soundly based in principle, and that will then apply to all parts of the United Kingdom.
That's it for this particular case. But how does that apply then for the Court of Appeal giving guidance in the future?
Well, issues will pop up in different jurisdictions and we'll have to be confronted on their facts to see if there are relevant differences. But we are ultimately here dealing with an issue which it would be very difficult to divide up between the United Kingdom jurisdictions, because it's either right or wrong. It either works or it doesn't work. There's no difference in terms of the reasoning. I respectfully submit that if Perrin Panathan...
It occurred to me that the only court that has experience of all of those three jurisdictions in this particular area is in fact the tribunal, as opposed to the Court of Appeal in one particular area. Well, so why shouldn't the tribunal be the arbiter of its own procedure?
My Lord, the answer to that is a slightly different one, which is that, and again I'll come back to it tomorrow, but the answer to that is a slightly different one, which is that, of course, the CAT is specialist, and of course, as Mr. Jow ringingly told you, they should be, as he put it, from BT and Ofcom, masters of their own procedure, but that comes with a rider. And the rider in BT and Ofcom, which completed the sentence which he partially quoted at you about masters of their own procedure, is provided that they apply the correct legal principles. And the correct legal principles are a matter in which their jurisdiction is ultimately controlled by the courts. Now, that may lead you to the Outer or Inner House in Scotland, it may lead you to the Court of Appeal in Northern Ireland, but ultimately all roads lead to you. And so if we're right about the correct approach in principle, I respectfully submit in principle that the answer that you give should be applicable to all parts of the United Kingdom and can't be determined or affected by the fact that the CAT is itself a UK-wide body. Well, we're a bit over, I'm afraid, but I hope it was convenient to answer the question.
Sir James, thank you very much. We will resume tomorrow morning. The court will now adjourn.